Welcome once again to Lehto's Law. Here's Steve Lehto.
This is a follow-up video to one I did not too long ago about mutual combat. And I asked the question, is mutual combat legal anywhere in the United States? The 50 states in America, is it legal in any of them? And I said that I was confused by this because people often tell me that it is legal in 2 states. Illegal in 48, but legal in 2. And they always cite Texas and Washington as being examples of the 2 states. And I found websites that show a chart, only 2 states where it's legal. And I pointed out that I couldn't find any laws saying it was legal. And the first reaction I got, and I had a lot of people go, Steve, you got that backwards. You don't need a law saying something's legal if it's you can do anything you want. I don't need a law telling me something's legal. Well, the fact that assault is illegal in all 50 states, you would need an exemption to assault for mutual combat to be legal. So you would need something telling you that mutual combat is legal, because otherwise the participants could both be arrested for assault. So yes, in that setting, you would need a law telling you it is legal. I'm not saying you always need a law to make something legal. I'm merely saying that to overcome the assault allegation, you'd need a law making it legal. So I said, I poked around and I found statutes in both states, and in one state it didn't seem to apply at all. And in Texas, there was a thing that kind of implied that you could be involved in mutual combat so long as nobody got hurt. And a lot of people didn't actually watch the video. They responded to the headline, and I had about 20 people email me the statute that I read in the video. And they said, have you seen this? I said, yeah, it was in the video. Oh, sorry, didn't watch the video. Okay. So I also had another guy send me some very angry emails. He was having a one-sided argument with himself. And he said, obviously, it's legal in all 50 states. Otherwise, all us martial artists would be in jail. And he starts telling me about how he's a Taekwondo practitioner, or at least he used to be. And I often forget that I've said things on my videos that I don't talk about a lot. And I always assume if I mention it once, people know this. I did a video a while back about how I used to take Taekwondo lessons for a few years. I actually taught Taekwondo. I have a 2nd degree black belt in Taekwondo, and I actually held the belt up in one of my videos to show it so that it was funny. And I admit I do not practice anymore. I've not been to an actual class led by a master in quite some time. I still remember the forms. I could do most of the things. If I tried to kick over my head, I'd probably wind up in the hospital. But I mentioned in the video specifically that many states do have an exemption to the assault laws for things like boxing and football and rugby, which are the examples I gave where there's people participating in a sport that involves contact. And the guy who is sending me the angry emails about martial artists said that otherwise we'd all be in jail. So obviously it's legal in all 50 states. Well, if you can't see the parallel between boxing and martial arts, we'll move on. But someone sent me an extremely interesting case, and I got to credit William for this. But just to make sure this is very, very clear, and I understand that this is an example of me going deep into the weeds on something, but I think most people who are interested in the legal system and how the legal system works will find this interesting. So let's back up to the very beginning. In most states in America, all states I'm sure, it is illegal to assault somebody or to batter somebody. And states have different definitions as to when an assault becomes a battery and so on. But generally speaking, if I whack you, that's assault and battery. So I went to the justia.com website just to get the most basic explanation of this, because I said that generally speaking, you cannot consent to a battery. I can't say, go ahead, hit me in the face as hard as you can. Go ahead. And if you hit me in the face as hard as you can, there's a chance that you can still be prosecuted for that. And we won't get into that for just a second. So keep in mind that in certain criminal circumstances, an apparent criminal act may have been committed, but an essential requirement of the crime is the victim was opposed to the crime occurring. When this happens, one defense available to a defendant is that the victim consented to the act, and thus the act was not a crime. So I've had several people say, Steve, if I consented to it, it can't be an assault, it can't be a battery because those are unconsented. Depends on the definition in your state. Many states don't say it's unconsented. So some crimes for which consent may be a defense include those that result in bodily harm, including assault and battery. In very limited circumstances, victims can be held to consent to these crimes. One common example is physical contact sports. Participants in a sports game are deemed to have consented to the physical contact and possible bodily harm that is an essential element of their sport. So, for instance, boxing, martial arts, hockey, football, rugby, basketball. Okay? Keep in mind, the elements of consent in these situations are: one, there was no possibility of serious bodily injury. Now you might say, Steve, I see people get hurt all the time in hockey. Well, serious bodily injury though? How often does it actually happen? How many games do you watch before you see someone carried off in a stretcher? I know it's happened, but how common is it? Two, the harm was reasonably foreseeable and the risk reasonably accepted. So someone goes into the game, into the boxing match, into the sparring match in the Taekwondo school, knowing the risk that they're taking, and they decided to accept it. Three, the individual received a benefit that justified the consent. There's some benefit to me sparring with a partner in Taekwondo. There's some benefit to boxing. There's some benefit to me playing hockey. In order to establish consent in these circumstances, 3 requirements must be present, and I just told you about them. Since these requirements are highly specific, they apply only in very limited circumstances, and typically some sort of athletic event. For instance, boxers or rugby players can be held to consent to battery that results from their participations therein. Now, what I was getting at originally with mutual combat was the idea that someone can walk up to somebody else and go, hey, I got a problem with you, buddy. And they say, I got a problem with you. And you say, let's go outside and settle this. And the two of you are going to go out there and beat each other up to get it out of your systems. That's mutual combat. We're talking about the mutual combat where somebody goes outside, or a duel setting, like in the old days, a duel, okay? So William sent me a note and said, Steve, check out this case from South Carolina, which I think answers many of your questions. And this does, because in my video I said the statutes all say that assault is illegal in all 50 states. And there appear to be some slight exceptions in some states that don't come right out and say that, yes, you can get involved in mutual combat. But there are settings where it might be considered that. And I said in my video, if it doesn't come from statutory law, it's got to come from case law, meaning that there's cases out there that say this is allowable in this state, and it goes way back in the case law, okay? Case called the State of South Carolina versus Taylor. It's a 2003 case. And we're going to talk about the case where the testimony varied widely regarding many of the relevant facts, but all witnesses agreed that at some point in the evening, these two people began arguing. The defendant testified that he was pushed by the other guy into a counter. All parties agreed that the defendant intervened either physically or verbally to stop a fight between two other people that was escalating. And then that man and the defendant engaged in a violent physical confrontation. The witnesses disagree about who started the fight and about its intensity at various points. At trial, one man testified the fight began when the defendant sucker punched the other guy. He reported, and that's when the defendant said, I'm not afraid of you, big man. And then he said, I'm not afraid of you either. And that's when the defendant said, we're going to hell or jail. And all of a sudden, he just hauled off and punched the other man in the head while he was sitting down. Now, the defendant testified that the other man threw the first punch and that he tried to withdraw from the fight. But the man would not release him and continued to beat him. Other witnesses asserted that the other man, not the defendant, attempted to quit. All witnesses agree that someone insisted the two take the fight outside, and they continued the struggle on the porch of the trailer and into the front yard. And I don't suppose the word trailer there should surprise anybody, but at some point thereafter, the defendant drew a knife and began stabbing the other person. The autopsy report disclosed the man was stabbed 15 times and died of those wounds. The autopsy reported that man was 6 feet 2 inches tall and weighed approximately 270 pounds. Physical examination of the defendant a few days after the fight revealed that he had undergone abdominal surgery in the weeks preceding the incident after a car accident, but indicated no cuts or bruises. The defendant was substantially smaller than the victim. At trial, the defendant admitted that he had done all this, but he said he did it in self-defense. Now, you're wondering, where does mutual combat come in? We're getting there. The trial judge charged the jury on self-defense, but also on mutual combat. And he said, "We also have a law in this state regarding what is sometimes referred to as mutual combat. The premise is in the law where two persons are mutually engaged in combat and one kills the other, and at the time of the killing is being maliciously done as murder. If it be done in the sudden heat of passion upon sufficient provocation or without premeditation, it would be manslaughter. One who provokes or initiates an assault and does not escape from the liability may find in self-defense a defense to a prosecution arising with respect to injury or death of their adversary. And where a person voluntarily participates in mutual combat for purposes other than protection, you cannot justify or excuse the killing of the adversary in the course of such conduct on the ground of self-defense, regardless of what the extremity or even peril he may be introduced to in the process of combat. Unless, in either event, before the homicide is committed, the person withdraws and does so in good faith, declines from the conflict, and either by word or by act makes that known to their adversary. Then, if the adversary pursues them, the aggressor may, upon the belief that they're in danger, they can injure or kill the adversary in defense." So here's the thing. The man got convicted of murder and possession of a weapon. And then the question is, did the trial court err in delivering a charge on mutual combat to the jury? And if so, was the defendant prejudiced by the charge? And here's the point. Here, the mutual combat argument went against him because they said that the concept of mutual combat in South Carolina means that if you've entered into mutual combat with somebody and you win because the other person doesn't survive the combat, you can be charged with murder. And if you say, no, it's self-defense, no, you were involved in mutual combat. It's not self-defense. So mutual combat here would hurt you. It's a description of a kind of a fight you can get into, but not legally. However, the reason this is interesting is that the court then goes on to a long explanation of what mutual combat is. So in general, the trial judge is required to charge only the current and correct law of South Carolina. The doctrine of mutual combat has existed in South Carolina since at least 1843, but has fallen out of common use in recent years. It says the case law does establish there must be mutual intent and willingness to fight to constitute mutual combat. Mutual intent is manifested by the acts and conduct of the parties and circumstances attending and leading up to the combat. Whether or not mutual combat exists is significant because the plea of self-defense is not available to one who kills another in mutual combat. In order to claim self-defense, the defendant must be without fault in bringing on the difficulty. So mutual combat is not something you'd want to argue in South Carolina. It simply means you cannot argue self-defense. But that doesn't mean it's legal. They're saying the concept exists, but it exists to overcome the argument of self-defense. So they do talk about it in other settings. The doctrine has most often been applied in situations where the defendant and decedent bear a grudge against each other before the fight in which one of them is killed. And they'd cite a case there from 1977. South Carolina has not explicitly required that the fight arise out of a pre-existing dispute, but other states have made that a prerequisite to mutual combat explicit. Texas and Colorado adhere to the rule that an antecedent agreement to fight must exist for the court to charge mutual combat. So again, Texas and Colorado are saying that mutual combat is a thing, but it's a thing for which you can be charged and you will lose your ability to claim self-defense. Georgia has limited the application of mutual combat in another way by holding that mutual combat arises only when the parties are armed with deadly weapons and that mutual combat does not arise from a mere fist fight or scuffle. In both those cases, right above, the disputes that ended in death began as fistfights, and so the court found that mutual combat charge was erroneous. So they're saying even to use it, you got a very specific grounds. As mentioned, mutual combat acts as a bar to self-defense because it requires mutual agreement to fight on equal terms for purposes other than protection. This is inherently inconsistent with the concept of self-defense and directly conflicts with the no-fault finding necessary to establish self-defense. So, conclusion is, although the court charged self-defense properly in this case, that charge was negated by the court's unwarranted charge of mutual combat. We find that the court's mutual combat charge acted as a limit on the petitioner's ability to claim self-defense and prejudiced him by transferring the state's burden to disprove self-defense forcing him to prove self-defense in violation of other case law. Therefore, they reversed the case, sent it back down for trial. So in this case, it's a murder case, and the man said it was self-defense. And the prosecution and the court apparently said, no, it wasn't. We think it's mutual combat. And by making it mutual combat, they took away the guy's ability to effectively argue it was self-defense. So mutual combat is not something you can legally do in South Carolina, but it's something you can be accused of doing that will hurt you if you go to trial. And the same is apparently true also in Georgia and Texas and Colorado and a bunch of other states. So the big question still is, are there any places where two consenting adults can go outside and get into just a fight by agreement, beat the senses out of each other, and maybe have one of them go to the hospital? And when the cops show up, you go, mutual combat. And if the guy on the ground goes, that the police are going to have to walk away because there's no way to prosecute that. And as of right now, I don't think there is. Now, I had several people send me a note and say, Steve, what about Chicago? In Chicago, there's a recent incident where there was some kind of a fray, and the police got involved, and they filed their reports, and the prosecutors declined to prosecute. And in the news stories, the police said the lack of prosecution was because it was mutual combat. The prosecution said, no, we didn't charge because there was not enough evidence to support the charges. And what is quite possibly happening there is that someone is calling it mutual combat because that's the best way to describe a situation where the police get involved because a bunch of people do something wrong, and it appears that everyone is kind of involved at the same level, everyone kind of suffered the same amount, and no one will testify. And I had several people ask me, they said, Steve, let's suppose I got into a fight with somebody. Mutual combat. We decided to go out back and settle it like men or like women. Assuming you're a woman. So you go out there and you're involved in fisticuffs, right? And eventually someone calls the police. We saw these two people wrestling outside. It looked ugly. Cops show up. You both stand up and it's like a cartoon. You got those things spinning around your head and bird noises and stuff. And the police go, who started this? And neither of you say a word. Now, the police walk up and they can see clearly the two of you are fighting. You've got bloodied knuckles, and they've got weird bruises on their face that just happen to match the shape of your knuckles, and vice versa. Okay? They know what you guys are doing, and there's no question you were doing it. And the police say, well, we want to prosecute somebody. Will you testify? Person doesn't answer. Will you testify? Person doesn't answer. Now, technically speaking, and I had several people ask me this, Steve, if the participants refuse to testify, can they still be prosecuted? Theoretically, yes. There's no law that says a victim must testify to get a conviction. But that's usually the best evidence you have if they're willing to testify. If they're not willing to testify, you can try to bring them in and force them to testify, except, of course, in a situation where either of them could be charged, they're probably both going to take the fifth. So instead of going down that long and fruitless road, you just go, mutual combat. Doesn't mean it's legal in the sense that there's a law on the books saying mutual combat is legal. And again, I'm not saying there's got to be a law on the books to say everything is legal. I'm simply saying to overcome the presumption that when you're hammering on somebody, that you're assaulting them and or battering them. So there you go. So there is a situation where the courts talk about mutual combat, and this is a great case sent me by William out of South Carolina, but you'll notice that the mutual combat ruling was something the guy wanted to get thrown out because it hurt him and his ability to defend himself legally with the claim of self-defense. So again, I'm still looking for case law or a statute in the United States that says specifically people can willingly go out and engage in a fist fight or something more violent, as long as they both agree that it is mutual combat. And if they do that, neither of them will be prosecuted. And if anybody can produce that case or that statute for me, I would love to see it because I suspect it does not exist in the United States. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law.
If you're going to do the wrong thing, do it the right way.